I would request participants not to write chat in the chat box when the meeting is going on. Concentrate on the meeting. Learning is more important than the attendance and greeting each other. Voice is clear?
Yes, ma'am.
Yes.
Thank you. Thank you.
Yes, ma'am.
Okay, okay. सुन लिया. Thank you.
Yes, ma'am.
ए श्रीवर्धन आगाऊपणा बंद करा.
Very warm good evening to all. Today's topic is about the cheating by personification and when you impersonate somebody. That is like when you are not somebody but you are pretending to be somebody. If I am Anita and I am pretending to be Sangeeta, then it's actually wrong. It is that simple. That is, you are impersonating somebody whom you are not there. We will try to understand this through a very small incident which happened in the year
Ma'am, your voice is too low.
1987. Just a minute.
No, madam, it is good.
Okay. In the 1987, there was a this incident with which happened with Tribhunas Bhimji Zaveri. It's an everybody knows it's a shop about the ornaments and diamonds. Now, what happened in 1987? A person named Mohan, he what did he do? He gave an advertisement in the newspaper and calling some candidates and asked them that he will give them an all the training about the raw and CBI to be appointed CBI officer. And he gather all these people, trained them to some extent, and took them to Trivandrum Bhimji Javeri. There, he went to the shop owner, Mr. Javeri, and what did he do? He cut off all the telephone lines. He asked them to shut down the cameras. Now, after this, he took all these samples with the all these appointed people whom he was trying to give job. And these people also work under him as they were thinking he was giving training to them. He took some samples of the gold ornaments and just disappeared from there. Till date, this mystery is not solved by the police. Where this man has gone is of no. There is no traces of his whereabouts till date from 1987. So it was a case of the impersonification, being a CBI officer to a shopkeeper, shop owner, and till date he is not available anywhere. Now, when this kind of things happen, it is called you're posing as a CBI officer or government officer or a police officer. That is called cheating by personification. Now, when you impersonate somebody, it is an offense under the Indian law. Now, it is a not Indian Penal Code but BNS, Bharatiya Nyaya Sanhita. Now, this TBZ story teaches us that this is happening. This happened in 1987. Until date, we find that there are incidents where digital arrest we find. We all, as a lawyer from the legal fraternity, we all know that all these things happen. Arrest will be happening in the police station, the court case will run into court, but these people are arresting people on digital arrest. They put some IPS officer's photo and they say I'm an IPS officer. If you are committed this theft, I found some account details and which is not a suspicious nature, then what do? They make them sit down in one chair, make them digital arrest and ask them to pay the money. This is also cheating by personification, that which you are not there. These things are happening in digital arrest. What we commonly know as a cyber crime, which is the biggest crime nowadays, white collar crime. Now we go to the sections of BNS. The first section I would like to bring to your notice is section 319. Now section 9, deceiving someone by pretending to be another person. It may be like you are saying, as I'm saying, I'm Anita originally, but I'm posing them as a Sangeeta or Suman somebody who I am not there. This is a case which happened. I will give a Tripura High Court judgment wherein a person with similar name and similar father's name, he got himself appointed as a government employee, but later on when there was a election card addresses of himself and his father's address, the addresses are different. Somebody got suspicious and his job was terminated by the company. So he has impersonated, he's the son of so and so person, and he is the person who has given the exam and he is rightly appointed, which was not true. So his job was terminated. So section 319, this kind of cases you will find who you are not there. Somebody may be posing as your husband, somebody may be posing as your parents to a small child. that we are the parents. It is a possible that somebody who is not in a of unsound mind person, and somebody comes and says, no, I am the legal heir, or I am the guardian of this person. This may happens in the cases. So section 319 is about cheating by personation, who which you are not there but you are pretending to be there. Now, next is one more section, 204. These sections are interrelated. Now, here, personating as a public servant, which you are not, like in TBZ, Tribunal Bhimji Zaveri case. What happens that you are saying, I am a CBI officer, I am a police officer. Now, previously, what used to happen, I am talking about 20 years back, some person who will say, I am a police officer, used to go and collect the haftas from the shopkeepers, also go and arrest people illegally and take money, take bribe. These things happen. So whenever a public you are posing as a public servant, it is an offense under section 205 of the BNS. Now, when we go to another section, the section 242. Here also is a false personification, but in court proceeding. Now, this is very serious. There are cases where accuses somebody else, but somebody else coming. Now, you see celebrity cases, the driver, the person who commits the accident does not come before the court, and another person comes and say, I am the driver, I have committed the accident, I am the one who was in charge of the car that time. So this is also a false personification, court proceeding, legal proceeding. Whenever you are before the court, you are confessing that you are. There are cases when divorce proceeding, the people used to bring the another lady instead of the real wife, and used to get the divorce. Now this was also something very serious. So now thereafter family would started asking the Aadhaar card or election card, and they have started asking the photographs of the person. So what happens whenever these things come to the picture or put to the knowledge later on in the light, actually the offense is already taken place. So you have to be very careful as a lawyer also. I had an occasion where people used to bring surety in the criminal trial. Whenever there is a bail granted and you have to bring the jamin to the court, they used to bring, he is my mama chacha. But then it's also your duty as a lawyer to find out whether surety is genuine or not. If the surety is not genuine, kindly do not do the work, because later on when it comes to the court's knowledge in the legal proceeding that you are also part of the, I would say that group which is providing fake surety to the court, is actually an offense. There was cases in the Pune where some group of lawyers were arrested by the police because they were giving the fake surety. So ensure that whenever a surety comes in the bail matters, be careful that surety is a relative or the close friend. Who you ask few questions to the surety, 1 2 3 4, whom you are standing as surety, you know what he has committed, you know the father's name, you know the native place. It's some basic question. You know who are in the family of the accused. If he's saying he's a friend, he will be knowing all the at least family friends. So whenever you are giving surety, you are helping the accused to provide surety. Be careful. Don't repeat this mistake anytime, because it may affect your sanad, your license to practice in the court, and you will also be liable for the prosecution. Now about section 242, one interesting case came before the Gujarat High Court in Ahmedabad. In the court premises, one person used to uh, take mediation of the and open the mediation center, and people used to come and mediate. And in one of the case, he passed an order for the government land. That time, it came to the knowledge of the court that he was posing himself as a judge in a mediation center. Now we all know in mediation there will be a judge mediation, but it will be in the court premises, not in the lawyer's chamber. So there were people who were not wise enough to understand his modus operandi. So these things happen. So cyber crime, and also now because of the AI generated, people can mimic your voice, AI generated images, videos, where there will be cases where your daughter or your son will call you with the same effect that send us money. Don't send, ask them to make a video call. I think the number is 1930 for reporting the cybercrime. Just check with that. If anybody in the chat can write that number for the cybercrime report. So everybody who are attending 285 pool, they will also be benefited, and you can help somebody. So always remember, I recently came across a video in the cybercrime that there is a golden period. Whenever cybercrime, cyber fraud is done, in that golden period is within 1 hour. Within a 1 hour, you should complain immediately, so that money is freeze. Even in cybercrime, where money is like freezed up or from the account, your bank account to another bank account. Recently, I came across a story of a person where he, as a father, he was having a LIC policy, but his daughter was not knowing, and somebody called his daughter, say that I have to uh, see the I have to send the money to your father, but your father account is not available, so you send the money. I'm an LIC agent. Now what happened in this case? Daughter and father stay in the same house. Daughter gave the OTP, account detail, everything. 30 to 40,000 from her account swept without her knowledge. So staying in the same house also, we do not ask our parents whether actually there is a reason why your account is not getting the money. So there may be LIC, there may be health insurance, there may be car insurance, there may be account, there may be your parents who are at the other place. See, nowadays it is said even the mobile hears everything. If you speak hold about the builder, evening you will start getting the advertisement from the builders lobby. This is what happens. Your phone is also listening. So there is a the technology is there, but sometimes it can, some people are using to misguide, to you, they are utilizing it not to make the life easier, but I would say to make the life difficult for the others. The crime has increased, cyber crime especially, because people sitting at home at the click of the mouse are doing all these things. So be careful. These are the section of personification, and along with there is one more law which you have to do, Information Technology Act. There are only few sections. Because of the cyber crime, this IT Act will also come into picture. But I would still say the more thrust will be on the BNS, because these sections are very important. They are also there in the Indian Penal Code. So now next we go to the next section of reading judgment. Dia is reading. She's from Nagpur. I'll share the judgment. This is of Rajasthan High Court, Jaipur. Dia, can you see?
No, ma'am.
You can't see? Wait. Now?
Yes, ma'am.
Yes, ma'am, it is visible.
Yes, ma'am.
Yes. Please, please. See, this is a judgment of the 1959 by Justice Ian Modi. Very simple judgment on the defamation. Dia, you can start from reading from here. I'll ask other people to keep yourself mute.
Okay.
Start reading.
Paragraph 1.
Yes.
This is a regular first appeal by the plaintiff, Lachman, in a suit for damages for defamation, which has been dismissed by the trial court. Paragraph 2. The material facts out of which this appeal arises lie in a short compass and may be briefly stated as follows. The parties belong to a village named Kuravar, the district Udaipur. The plaintiff in a punch of the Gram Panchayat, Kuravar. The respondents are 28 in number, and of this, about half the number are Mahajans, and the rest belong to various other communities. The plaintiff's case was that on 18 March 1952, the defendant made a report, Exhibit P1, to the station house officer, Police Thana Kuravar, which translate in English read as follows. It is prayed that the undermentioned gundas are misbehaving and harassing us, the applicants. On Chaitwadi, 3rd and 5th, they perform themselves into a assemblage of number of persons of which they were the leaders, and they have treated us very shabbily. Inf- Information various has been given to the police from time to time. Our shops have had to be closed. Therefore, please make adequate arrangement. Otherwise, our life and property is in serious danger. Urgent action is solicited. The name of the plaintiff was mentioned as one of the 7 persons against whom the aforesaid complaint was made. The plaintiff's case further was that the defendant had made the above mentioned complaint to the sub inspector falsely and maliciously with intent to disgrace the former and lower him in the estimation of the public. Consequently, the plaintiff instituted the present suit in the court of the civil judge Udaipur for damages amounting to rupees 10,000. These damages appear to have been claimed not as special damages but generally. Paragraph 3. The defendants respondent with some variance which is not material for the purpose of present appeal admitted that they had made the report to the station house officer Kurawar, but they contended that they had made the said report out of the feeling of self-protection and with a view to see that adequate arrangements are made for their maintenance of public peace and tranquility in their village. It is evidence, ma'am,
Yes.
it is
Perfect.
evidence that there was commotion in this village in the month of March 1952 on the occasion of the Holi festival. It is admitted that some ancestor of then Jagirdar of Kurawar had died on the holy day a few years ago, and therefore the usual festivities which take place on Falgun Sudi 15, which is the day of the Holi, and the following day are postponed in this village to 2 to 3 days, and the customary festivities are observed on Chaitwadi 3 and a day or two following. It is also in evidence that the defendant, who are mostly Mahajans and their friends, had observed the holy ceremonies of Falgun Sudi 15 and Chaitwadi 1st, that is the 11th and 12th March 1952, regardless of a forced practice. This piqued the Jagirdar and the friends of the Thikana like the plaintiff. Consequently, the case of defendant, as disclosed by their evidence in that, ma'am, consequently, the case of the defendant, as disclosed by their evidence, is that the plaintiff and certain other persons who had been named by them in the report exhibit P1 had taken out procession on Chaitwadi 3 and Chaitwadi 5th, during which they carried effigies of the defendants Chaganlal, Chaganlal and Pyar Chand, and gave them shoe beating while the procession was being carried in the village. The result was that feelings ran very high in the village, and there was rioting. And the Mahajans had to close down their shops. And it was in these circumstances that the report exhibit P1 came to be made to the police. The defendants therefore contended that they had no desire to defame the plaintiff or anybody else, but that what they had done was in protection of their own interests and for preservation of peace and tranquility in their village. The defendants also pleaded that the police had prosecuted 6 out of the 7 persons against whom they had made the complaint, and among these 6, the plaintiff was one of the persons who had been silent. The defendants denied that they had any malice in making the complaint, which they did to the police, and they prayed that the plaintiff had filed this suit merely to harass them, and therefore they also prayed for grant of special damages to them under section 35A of CPC. Paragraph 4. The learned civil judge, after recording the evidence of the parties, dismissed the plaintiff suit. The material finding arrived at by the learned judge may be shortly stated as follows. He held in the first place that the defendant had not given publicity to the contents of Exhibit P1 at any place, and therefore there was no publication of the alleged defamatory matter. The learned judge further held that Exhibit P1 was absolutely privileged in as much as the defendants had made the report in question to the police for reasons of self-protection. Ma'am, ma'am,
You can continue from here.
as to the background against which this complaint happened to be made referred to above, the finding of the learned judge appears to be that the peace and tranquility in village Kurawad was greatly endangered as a result of doings of the plaintiff and his companions, and the learned judge arrived at this finding chiefly relying on the evidence of D.W. Botnia, a Sarpanch of the Kurawad Gram Panchayat from 1945 to 1952. The learned judge also appears to have believed that as a result of all this, the superintendent of police himself came over the village and that armed police force was posted there for some time, and that the plaintiff and his associates were prosecuted for rioting and some other offences, and case relating thereto were pending at the time the learned judge decided this case. In this view of the matter, he came to the conclusion that the contexts of Exhibit P1 were absolutely privileged and no action could lie with respect to them in a civil court. The learned judge also came to the conclusion that the plaintiff was a man of questionable status and reputation, and that he had entirely failed to prove that no had sustained the quantity of damage claimed by him. In the result, the learned judge dismissed the plaintiff's suit. The present appeal had been filed by the plaintiff from the aforesaid judgment and decree. Paragraph 4. It is contended by learned counsel for the plaintiff that the findings of the learned judge of the trial court on the question of absolute privilege and as to want of publication are wrong. Learned counsel further contended that if this court came to the conclusion that it was a case of a qualified privilege, then an issue as to whether the statement in question was acquitted by malice or otherwise should be framed and the case remanded to the trial court for finding on this issue, and thereafter the whole case should be decided afresh. Paragraph 6. I shall take up the question of absolute privilege first. The question at once arises what is an absolute privilege and whether a report made by a person to the police officer in circumstances like those of the present case can legitimately fall within the protection of this defense in a civil suit for defamation. A number of judicial decisions were cited at the bar in this connection, but I consider it unnecessary to refer to them in particular. It is indeed well established that, ma'am,
Yes, complete this paragraph.
it is indeed well established that the plea of absolute privilege means that, by a sort of legal fiction, the law, owing to compelling consideration of public policy, invest statements made upon certain occasions with a special protection, so that all statements made on such occasions, even though they may be defamatory, cannot be made the subject matter of litigation in courts of law, and no action for defamation will lie in respect of them.
Okay. Wait.
Okay.
Thank you, Dia. Very well read. Thank you, everybody. Very well read, Dia. This was a very old case of defamation. Because of the positive time, we couldn't complete the case, but everybody knows which judgment it is. If you scroll the video, you will know.
One minute, ma'am. Only the focus has been given to the essentials of defamation by the Honorable Court.
We will speak later. Not now. Any question, you can speak later. Now, so this try to go through this judgment because the language is really good, and also one incident of the Mughal Kal is discussed there about the holy and all that. That was also taken in another judgment. It is by Justice Kaju, who was a Supreme Court Chief Justice as well. So check this judgment again, because it is one of the good judgment and it is very old than 1950. Even the language about the defamation is very good. Tranquility, peace, then defamation words are used in a very better way. Now next we go to the legal vocabulary. Let me share it. Legal vocabulary is not something about learning English, but I would say it is learning about the legal language. It will help you to speak better in legal language. This is leave. If you see, the leave is a small thing. Leave means chutti lena kuch bhi. But if you speak in the legal parlance, the legal meaning is different from literal meaning. Formal permission granted by a court to perform an action. Okay. Now, the contention for the opposite party, that is plaintiff, is that the second suit was not barred by Order to Rule 2. Order to Rule 2, CPC have to go and find it out, as he had omitted to claim the relief of ejectment in the first suit with the leave of court. So, court ka permission lena tha. Now, here leave does not mean chutti or holiday. It's a leave of the court, permission of the court in a meaning. So it's a very different way. Travesty. Travesty, we always hear it's a travesty of the justice, farce or sham or fake. Now, continuance of any purported investigation against the petitioners would be a gross abuse of process of law and undoubtedly a travesty of justice. Sometimes you can use these things while arguing the bail application also in cases where you are requesting for the order. If this is not given, it will be travesty of justice. Now, next word is deprecate. To express strong disapproval or criticize something. I am deprecating this practice. Now, this is a sentence from straight from one of the judgment. In the case of Dhirendra Chamoli and Anodar versus State of UP, report in 1986, wherein the Supreme Court deprecated the practice of employing casual workers in organizations which are in existence for long on ground of the organizations being temporary and directed and sanctioned the post recommended for regulation of such workers. Sentence is long, but just see the words. Wherein the Supreme Court deprecated this practice. Supreme Court ने disapprove किया employing casual workers को इस तरह से. If you are employing for 12 years, this was the ratio of that judgment. Now, this is albeit. Although, despite. Now, normally we write although, but albeit here, albeit, now see, despite this stated thing, even though. Surinder never approved of Sanjay's relationship with Priya till he was alive, albeit he had not met her. जबकि वो उसे मिला भी नहीं था. Although he has not met. Cognate. Same or similar nature or relationship offenses that are closely connected. Cognate relationship is also there in Hindu law if you check. Two other cognate sections to which our attention has been drawn are section 25G and 25H. The meaning of this sentence is that these two sections are similar cognate sections. जुड़वा नहीं बोलेंगे लेकिन similar. Exposition. Formal explanation of a legal position, theory or argument. The appellant brief began with a clear exposition of the constitutional issues at the heart of the case. Formal explanation, starting of a legal position, theory. Abrogation. To formally cancel, annual means cancel again, the meaning is, or repeal a law, treaty or formal agreement by authoritative action. The rule was abrogated in England. England में rule abrogate हो गया कब? By statute. Statute means law. After having remained in force for 136 years. Illusory. Deceptive. Illusory meaning itself is deceptive or likely to mislead. The amount fixed must not be illusory. Alienate. Alienate, isolate, turn away. अलग थलग करना. Posters attempting to alienate Jammu and Kashmir JNK residents from India sufficient to attract UAPA. UAPA Unlawful Assembly ये एक्ट है जो in the safety for the safety of the nation UAPA this act is used. Invidious, an action situated or remark that is unfair to other. In the instant case, the end result is an invidious discrimination, perpetrating sexual differences. So it's a little difficult word, but you can use it at least in the drafting. Speaking this will take some time, but we can use in the drafting and slowly it will come in our regular practice. If you start learning these words which are actually very important from the point of view of the practice. Now next we go to the court etiquettes. We all hear every day few cases where the lawyers fight in the court, clients fight in the court. Even we are exposed at some places in the court where the opposite client shouts at us. But there we have to keep a demeanor, I would say, of behavior or dignity, where you can, I would say, respect yourself, dignity of the court. Also, do not fall into this trap, because there are cases where the clients are at logger's end and they take out their frustration on us. This happens. Also, there are cases where another lawyer is shouting, I am also shouting, and the judge from the dais will say, maintain the decorum of the court, I am not hearing anybody, go out. So this actually does not help ourselves also and our clients also. So there are some basic etiquettes, court etiquettes, that which we should follow. At times we may lose temper, but then I have been taught, I was in a Thane court, I was taking the cross examination, and the because see, you get personal when you know the clients for a long time in the matrimonial disputes. This man was not giving the reply which I was expecting in the cross examination. Now, in such a situation, I got little angry. The judge sahab on the dais told me, Madam, Ashilala, he told me in Marathi, which I am telling here, Ashilala रागवण्याचा अधिकार आहे, वकिलांना नाही. वकिलाने शांतच राहिले पाहिजे. I learned the biggest lesson of my life in this case, that I should be in control of myself. It was a court etiquette that no, ma'am, you cannot lose your temper. So sometimes judges also teach us. So listen to them carefully, because the judges are trained mind. They know actually what they are doing. So always remember, try to sit in courts where big lawyers, senior designated lawyer. I hope everybody knows the difference between advocate and senior advocate. Senior advocate are the advocates who are appointed either by the Supreme Court or the High Court. They are designated. They are not appointed. They are designated senior advocate. Their gown will be in the square or rectangular shape, black gown. If you go to any High Court or Supreme Court, you'll find many lawyers having the different gown than the regular people. Now, the first thing in court etiquette, I will request all of you, respect the judge. He may be against you or he may be in favor of you. Always respect the judge. If he's in favor of you, there is no question of getting angry. But even if he is against you, because next very day you may get a case in his court. And if you take that previous day's temper to the court, maybe the second case is also going to be ruined. And who is it? See, it does not help your client to get angry. I was taught by my senior Manohar Naik sir. Again, he told me, प्रिसाइडिंग ऑफिसरशी भांडायचं नाही, प्रिसाइडिंग ऑफिसर से झगड़ा नहीं करना है. प्रिसाइडिंग ऑफिसर में the judge who is sitting there. Be kind and courteous in a word. Kind, you are not giving anything. Only your word should be very polite. The perfect word is be polite before the judge. Even if they are rude to you, even the other side is rude to you, be polite, because judge is handling 50 cases, 100 cases. He may get irritated. He is also human after all. But we are handling 1 or 2 cases in a day. So we can be polite while submitting before the court. And if you're polite, 100%, there is a chance, even if you don't get a order in your favor completely, there is a possibility you may be according while taking the date. You may be according that sometime I tell the honorable court, can I come in the second session? I stay in Mumbai. This is a Panvel court. Can I request for the second session? Or can I at least request for by 1 o'clock, 11:30? See, this is what I used to go to Gondia court from here. So I used to get late. I used to leave home at 3:30 in the morning. But then it was very difficult. After flight, there was a train. And then again, I have to walk for 15 minutes. So I used to reach by 11:30. But I used to request. Once you request the judge, he or she knows that you are coming from outside. They are bound to help you. But your words should be polite. It should be very good. There are so many other things. But the first thing I would request to be polite to the judge. And nowadays there are cameras everywhere. So you are watch everywhere. You are watch. And understand the judge position. He's not hearing one case. He's hearing 50 cases. I've seen coming to the court late and they say barish ho gaya. Tomorrow I'm in a personal difficulty. Don't mention all this. Just say I'm unable to come. एकदम आपके गले तक आता बोलो आई एम इन पर्सनल डिफिकल्टी. Don't say it is my birthday, I'm not coming tomorrow. There you can politely, there is a function in the family. Simply you can say there is a function in the family. I may be accommodated for a date. Now, next is I have seen people eating chewing gum or eating pan, or sometimes eating in the courtroom premises. See, there is a bar room, there is a lunch room. If it is not a go to canteen, or sit in a corner. Don't eat, drink in the court. Drinking water is completely fine, but that also, if there is somebody is in front of you, go behind and drink water. Don't drink in front of the court unless there is a medical emergency, something like that. You because this is a court where the judge is watching you, and you should not disturb the proceedings of the court. You have no right to disturb him, because he is handling not a file of somebody, he's handling somebody's life. It will be a maintenance case, it will be a conviction or acquittal in a criminal trial, it will be a land acquisition matter in a civil matter. So you have to be very, very careful while you are in the courtroom premises or in the courtroom itself. Maintain a decorum of this. Another thing I would say, be silent. Sometimes we whisper in each other's, uh, the person sitting next to me, we talk. The judge is working there, two lawyers are arguing, and we friends sitting behind talking. If you have a serious talk, please go out. Otherwise, watch the proceeding. Don't talk. कोर्ट में अपना कोर्ट नहीं चलाना, मीटिंग में मीटिंग नहीं होनी चाहिए. Now also when our meeting is going on, I see so many here, so many noise voices. Every day we are putting, kindly keep yourself on the mute, because it's not inadvertently you may be making a mistake, but be careful, because there are 300 people sitting here. I have, or anybody on this dais, on this Zoom meeting, has no right to disturb the other 299 people. Be careful. If you have urgency, leave the meeting. If you have urgency, leave the court premises, come outside. Another very important part is your cell phone handling in the court. I was lucky enough to attend a lecture on psychology of the judge at Madurai High Court. Luckily, I was there and there was a lecture in the evening. He was a doctor and psychologist. He had also remained a dean, and that lecture is not available on the, I think, YouTube. And he said so many things. He said, when you are scrolling, the judge is watching. He is above sitting you, maybe 3 to 4 feet, and he can watch you. That we are scrolling or we are reading. You may say that I was reading a judgment. Don't do that. Sit in a corner where the judge can't see you when you're scrolling the cell phone. Because nobody likes. If I am sitting here and I don't like people to having noise or speaking in between the meeting, the same thing happens with the judge. He's a judge. He has his own aura, his own protocol. So be careful when you are. If you have anything urgent, please come outside and talk on your cell phone. Don't start sending SMS and all that, because the judge is watching you and this affects you. But instead of going to the through the cell phone messages, if you look at the judge like this, what I will feel, what the people will feel there, they will feel that actually we are giving attention to the judge, and this may help you in the long run to make eye contact with the judge, and he or she may know you. If you appear 2 3 times before a judge, the judge should know your name, because you're appearing regularly, at least by face. And people say there is a lot of importance of face value in the legal practice. So what is face value? Kya hota hai? Face value, the judge knows you. So how do you create face value? This way only. The face value is created by the way you interact or you behave in the court. Face value ऐसे create नहीं होता. Either you have a lot of matters appear every day, but then also there is a reason that if you, even if you have a lot of matters, you have to be very careful, because that the judgment or the order in every matter is going to affect your clients and ultimately your practice. Next is dress code. Dress code is the most important part. Before you speak, your clothes speak. Always remember, before I speak, my clothes speak. So whenever you go to the court, go well dressed. It doesn't mean you should have a 5,000 rupees shirt or trouser or a Punjabi dress or sari. No, no, not necessarily. It can be simple, black and white, which is the required in the court premises. I don't advocate color unless you are wearing complete gown and the coat, because cream is also fine. Light colors are also fine. Red, yellow, these are not the colors to be worn before the court. Always remember. Be careful. Unless there is a function in the court premises, you have to be dressed up as a like a lawyer. This is the uniform. There is no sanctioned uniform. But if you go to bar council rules, you will definitely find something there which says these are the colors. Uh, so some people may feel offended, but when you go to court, you cannot wear the sleeveless. You are not supposed to wear the jeans. You have to be informal. I've seen people coming in the sleepers to the court. No, not done. You have to be properly dressed up. When you go to the some temples, there are rules. When you go to the some hotels, there are rules. I have heard that there are pubs where they say you have to wear this kind of clothes. There is a rule. So you have to, if you go to gurdwara, you have to do your head, you have to keep something. For man it is something, the handkerchief, or for woman is the odni or sari pallu. So you have to, there are some rules. So there's always remember, it is a temple of justice. In temple of justice you can't just go. It is the most positive place for a people who is going, asking there, बोलते न्याय मांगने आया है, वहां पर जस्टिस मांगने आया है. So be careful. We are not there. So the way you dressed up is all going to affect yourself also, because whenever you wear new dress or you wear good clothes, it affects your psyche, your psychology. So psychology is also about how I behave and how I perform. And this all comes from all these three things. I met a senior lawyer at the Gwalior High Court, and he was very senior, about 78 years old. I asked him what is the secret or what is the best things I can learn from him. He said 3D: discipline, dedication, and dressing up. See, discipline and dedication I know. But he told me, even in the 78 years old, I wear the best of the clothes when I come to the court. Because this is the place where I will not, I sell myself, I market myself, but I present myself. So whenever you are presenting before the court, be in a perfect uniform, which suits the court protocol, court's respect. We have to keep the dignity of the court. Then sometime we I also see people are in a hurry to mention their case. If there is an emergency at your home, please mention that I have to go, my mother is sick, I have to go to hospital. But every day is not an emergency. Don't mention. As a junior, I have never mentioned, and now even after 25 years of practice, I do not mention my matter unless there is a lot of emergency. I sit before the court. I've seen when I sit before the court, I'm looking at the judge. The judge himself, madam आपलं काय आहे, तुमचं काय आहे, वो पूछ लेते हैं ऐसे. बिकॉज कोर्ट जो चलता है बोर्ड वाइज चलता है, दे गो बोर्ड वाइज, सीरियल वाइज. There is a board. Those who are practicing law, they all know. So never ever go go and just mention your case unless until there is a protocol or there is a way where everybody is mentioning. Then be in line. And though when other side is arguing, do not speak. Let the other side finish, your learned friend, and then you argue. And how do you address your other lawyers? He, not he or she, my learned friend, my learned sister, my learned brother. If you go to High Court side, they will say my learned brother, my learned sister. Even at the dais of the Supreme Court and High Court, I have seen when male and female judges there, they will say my learned sister just told. So much respect they give to each other. This is what we can learn from them. So there are a lot of court etiquettes, and the best thing I would say, be silent in the court premises, because whatever you speak is going to affect your case. And keep your energy, save your energy for the perfect timing when your case is called out. So when you're silent in the court premises, in the courtroom, and when your turn comes, you speak, your thoughts are actually arranged properly and you can speak better. So always remember, look into either your file or look at the judge. how he is handling the other people's cases. So this will help you. This was in court etiquette. There are so many things, but this was what I could discuss today. So it's already 10:25. We'll leave for the day today. Thank you so much, everybody, for attending such a huge number.
Thank you, ma'am.
Thank you,
Thank you,
ma'am.
madam. Thanks a lot.
Thanks a lot.
Thank you, madam.